Good afternoon, students, staff, as well as invited guests joining us both in person here and also virtually. You are all welcome to the 2025 Milvain Lectures. My name is Professor Gideon Christian. I'm an associate professor here in the faculty. I co-direct the Trial Advocacy Program along with my colleague, Professor Milvain Lecture. Welcome to the 2025 Milvain Lecture, to be delivered by a very special guest in our midst this afternoon. To get this event started, it is my pleasure to invite my colleague, Andrew Showalter, for the traditional land acknowledgement.
Thank you, Professor Christian. Tanse oke abatech dadanastara. Good afternoon, everyone. It is my honor to welcome you all, and I'd like to acknowledge the Honourable Judge Dillard and welcome you, sir, to not only Canada, but to this territory specifically, and in accordance with the protocols of the Indigenous legal traditions that exist in this place, where the Bow and Elbow rivers meet, that we know as Mohkinstsis, Winchispa, Gutitsi, Otosquini, and the city of Calgary. Indeed, through generations and through the cultivation of new relationships, the protocol of recognize the distinct peoples of this increasingly shared territory was an affirmation of the legal orders, customs, and ways of life of the peoples and communities of this place. In this regard, I welcome all of you to our faculty today and humbly recognize that we are gathered on Treaty 7 territory and acknowledge the Blackfoot nations of the Piikani, the Kainai, and Siksika peoples, the Stoney Nakoda nations of the Chiniki, Bearspaw, and Goodstoney peoples, and the Dene nation of the Tsuut'ina peoples. In addition, we acknowledge that this is Battle River territory, part of the historic Northwest and homeland of the Métis people of the Opa-Tip-Mesawak Métis Nation. Today we continue, as we have for generations, to share ideas and to learn, walk, and grow together as individuals and peoples with shared histories and stories in a good way. And it is in that spirit that we gather here today. And so thank you, Miigwech, merci, and Professor Christian, I'll let you continue. Thank you.
Thank you, Andrew, for the traditional land acknowledgement. So now that we have event traditionally started, it is my pleasure to invite the interim dean of the University of Calgary Law School, Dr. Evaristus Oshenibo, who is going to be introducing our 2025 Milvain Visiting Chair. Dr. Oshenibo.
Thank you so much, Professor Christian. On behalf of the faculty, staff, and students, I'd like to welcome you all to the 2025 Milvain Lecture. Now, in particular, I would like to welcome a distinguished guest, the Honourable Stephen Dillard, to the city of Calgary, the country of Canada, and the most innovative law school in Canada. Coincidentally, I was joking with Judge Dillard this morning when he mentioned to me that this is his first time in Canada. I said, well, you can already attest to the fact that we Canadians are not only good-natured, but we're just good people. And he can attest to that. He mentioned to me that he noticed that right at the moment he got to the airport. So it is our hope that all through your stay here in Canada, you're going to see the good side of all of us Canadians. So you're welcome. Now, I would like to acknowledge the presence and the sponsorship of the Calgary Bar Association, who's represented here today by Zaylin Laku. Now, what you may not know is that the Milvain Lectures started way back in 1979. It's been sponsored by the Calgary Bar Association since that time. They were started in honor of Justice James Milvain of the Trial Division of the Supreme Court of Alberta, as it was then. Justice Milvain retired at the beginning of 1979. But since his retirement, every year we've held the Milvain Lectures here at the law school. And that's all because of the sponsorship of the Calgary Bar Association. So to the Calgary Bar Association, we say thank you. At this point, I'd like to acknowledge the individuals who have worked tirelessly to bring the 2025 version of the Milvain Lectures to fruition. I'd like to begin by acknowledging the efforts and the good works of the two professors responsible for trial advocacy here at the law school, Professor Gideon Christian and Professor Will Mashim. Please give them a round of applause. I would also like to acknowledge the good works of Andrew Showalter, our coordinator of indigenous studies, as well as Thomas Wen. Thomas, where are you? The president of the SLS, and Tammy Oguntona. Thank you all so much for your assistance. Later in the day, you are going to be seeing a lot more of Thomas and Tammy. Now, at this point, I would like to briefly introduce the 2025 Milvain Visiting Chair in Advocacy, the Honourable Stephen Louis A. Dillard. Currently, Judge Dillard is the presiding judge at the Georgia Court of Appeals in the United States. Prior to his appointment to the bench, Judge Dillard was in private practice. And as you know, appointments to the bench in the United States is for the most part by way of elections. And so 3 consecutive times, Judge Dillard has been elected to a full 6-year term, 3 times, 2012, 2018, and 2024. On July 1st, 2017, Judge Dillard was sworn in as the 30th Chief Judge of the Court of Appeals of the state of Georgia for a 2-year term, which ended on June 30th, 2019. He currently serves as the presiding judge of the 4th Division of the Court of Appeals of the state of Georgia. Judge Dillard is a proud graduate of Stanford University. In fact, he showed me the crest of that university this morning. As he sits here with us, he has the crest with him. He's also a graduate of the Mississippi College of Law, where he got his JD, and is currently completing a unique LLM for judges at Duke University. He is the first American to be the Milvain Chair in Trial Advocacy here at the University of Calgary. So, on behalf of all of us, it is my pleasure to welcome Judge Dillard to the podium.
All right. Well, thank you, Dean, for that warm introduction. And it has been wonderful to be here with all of you today. I got to say, I live in Macon, Georgia, which is about 75 miles south of Atlanta. And as you might expect, we don't get a lot of snow. Well, it is snowing in Macon, Georgia right now. So apparently I had to leave in order for us, and my bride is very happy about that. So anyway, it's wonderful to be here with you today. And I have a confession to make. I'm a bit nervous. Although I've done a lot of public speaking in my many years as a lawyer and judge, I've never been to Canada before, and I'm sure it won't surprise you to learn that this is the first Canadian award or designation that I've ever received. Indeed, as Dean pointed out, it's my understanding I'm the first American to ever hold the Milvain Visiting Chair in Advocacy, so I'm definitely feeling the pressure to deliver a rousing and memorable lecture today. And just so you know, I've gone through several drafts of the speech, some of which included a joke about bringing the Flames back with me to Atlanta, as well as a few carefully selected references to Nickelback, Tim Hortons Donuts, and beloved Canadian pop star Robin Sparkles. For those of you who watch How I Met Your Mother. In all seriousness, though, I'm honored to speak with you today about an issue near and dear to my heart, professionalism and advocacy. But before I get to the specific topic of professionalism I'll be addressing, I want to say a few words about what it means to be part of a profession rather than simply having a job. Now, before I offend anyone, I want to be clear. All work has inherent dignity and worth. But historically speaking, a profession has always been viewed differently by society. Not better necessarily, but certainly different in nature. Indeed, the Oxford English Dictionary defines profession as, among other things, an occupation in which a professed knowledge of some subject, field, or science is applied, a vocation or career, especially one that involves prolonged training and formal qualification, and our students know all about that. And originally, the word profession meant a sacred vow that was given during a religious ceremony, indicating that someone was dedicating their life to contemplation and not earthly pleasures or personal advancement. Unsurprisingly, the legal profession borrowed heavily from these religious practices and traditions in the giving of vows, the swearing of oaths, and the dedication to something beyond just personal pursuits. So to this very day, the practice of swearing an oath for a higher purpose evinces the legal profession's commitment of seeking to ensure that the legal system is equally available to all, to be a voice for the voiceless. The legal profession, then, has always been a public profession. As Roscoe Pound once aptly noted, that under a government of laws, the lives, fortunes, and freedom of people are wholly dependent on the enforcement of their constitutional rights by an independent judiciary and an independent bar. Now, I want to pause here to emphasize the importance of not only having an independent judiciary, but also an independent bar of lawyers, which is absolutely essential for not only preserving an independent judiciary, but also the rule of law itself. The law, then, is not, or should not be, simply a means to make money or achieve some sort of perceived societal status, although I fear many view it that way. To the contrary, the law is a calling. For some, it can be a quasi-religious calling. For others, it is purely a civic or secular calling, and for many, it's a combination of both. But everyone who seeks to become a lawyer and part of the legal profession is committing themselves, whether they fully understand this or not, to a life of public service. Let me say that again. Lawyers and judges are public servants. Put another way, lawyers are stewards of all the legal rights and obligations of all the citizens. And it's incumbent upon all of us who are fortunate enough to call ourselves judges and lawyers to be faithful stewards of the sacred trust society has given our profession. As the Supreme Court of Georgia, in my home state, has emphasized in its aspirational statement of professionalism, there are unfortunate trends of commercialization and loss of professional community in the current practice of law. These trends are manifested in an undue emphasis on the financial rewards of practice, a lack of courtesy and civility among members of our profession, a lack of respect for the judiciary and for our systems of justice, and a lack of regard for others and for the common good. As a community of professionals, we should strive to make the internal rewards of service, craft, and character, and not the external reward of financial gain, the primary rewards of the practice of law. In our practices, we should remember that the primary justification for who we are and what we do is the common good that we can achieve through the faithful representation of people who desire to resolve their disputes in a peaceful manner and to prevent future disputes. We should remember, and we should help our clients remember, that the way in which our clients resolve their disputes defines part of the character of our society, and we should proceed accordingly. I absolutely love that language, and I couldn't have said it better myself. So how do we as lawyers do this? There are, of course, many ways for lawyers to build trust in our respective communities, but I want to focus on one aspect of professionalism that I think is particularly important. One of the first things law students are taught is that as lawyers, they will be expected to zealously represent their clients. But what exactly does this mean? Unfortunately, the imagery conjured by this turn of phrase only serves to perpetuate the pernicious notion held by many non-lawyers that lawyers will do anything it takes to win a case. So while the sentiment behind the charge to zealously represent one's clients is no doubt well-intentioned, I think it's long past time for lawyers to recast the manner in which we describe the nature of the attorney-client relationship. For my part, I've been preaching this message since the time I was sworn in as a judge, but it wasn't until recently, in fact, around the time I accepted your gracious invitation to visit Calgary, that I happened to stumble across a wonderful replacement for the term zealous advocacy. Resolute and honorable advocacy. Does anyone know where that comes from? Anybody? Well, it's in your Code of Professional Conduct, Code Section 5.1-1. And it provides, and once again, I love this language, that, quote, when acting as an advocate, a lawyer must represent the client resolutely and honorably within the limits of the law, while treating the tribunal with candor, fairness, courtesy, and respect. Now, if this language doesn't perfectly encapsulate what I believe the bench and bar wants and should expect from its lawyers, then I don't know what does. But for some strange reason, we persist as a profession in speaking as if zealotry and representation is the highest ideal in being a lawyer. It is not. Lawyers need to understand that they have duties beyond those to their clients, to the bench, the bar, the community writ large, and the rule of law. Indeed, the rules of professional conduct in both the United States and Canada make this abundantly clear. But there's a compelling reason beyond mere ethical compliance for taking a more holistic rather than mercenary approach to one's law practice. It makes for far better lawyering. At the heart of a holistic approach to the law is a recognition that the disputes we handle as lawyers are not about us. Ideally and historically, lawyers have been servants. Our clients come to us when they are vulnerable and in dire need of guidance. And the last thing a client needs is a lawyer who fans the flames of discord. What a client does need is for someone to dispassionately analyze the situation and come up with a game plan for quickly resolving the dispute, i.e., a problem solver. Unfortunately, this approach is much more difficult to market to a person in the midst of emotional turmoil. Prospective clients will often, perhaps understandably, express a desire for a pit bull attorney, one who will inflict pain and misery on their adversaries. But that's not what a client needs, and a lawyer has an obligation to channel the client's emotions in a constructive manner. This does not just promote the cause of professionalism, but also inures to the benefit of the client. The reality is that many cases are won and lost due to the reputations of the attorneys involved, and a fanatical, win-at-any-cost lawyer is not doing the client's cause any favors. So while it may warm a client's heart to hear her attorney bluster on about how she's suffered a grave injustice, if that rhetoric has no basis in the law or undermines a valid legal position, then it ultimately serves no purpose. A good attorney knows this to be true. A good and capable attorney recognizes that effectively representing a client begins and ends with zealously guarding her reputation and going above and beyond the baseline of ethical standards imposed by our profession. Again, I come back to the inspiring language contained in your own professional code of conduct, charging lawyers to, when acting as an advocate, represent your clients resolutely and honorably within the limits of the law. And this applies not only to your interactions with the bench, but also those you have with your fellow lawyers every day. Outside of the biblical context, I don't know anyone who likes dealing with a zealot. No one says to their friend group on a Friday night, hey, let's invite that zealot to hang out with us. And for the law students and young lawyers here today, I want to share something with you that you're probably already aware of. Practicing law is really challenging. And unfortunately, many lawyers make life and the practice of law much more difficult than it needs to be because they've bought into the idea that the only way to be an effective advocate is to make everyone on the other side miserable. But this tactic rarely works, and it only serves to harm your professional reputation as well as the entire legal profession. So I want to pause to give you a piece of advice on how to deal with an unpleasant or mean-spirited opposing counsel. Inundate them with professionalism, civility, and kindness. This should come naturally to Canadians. Not so much with my country. This is much harder than it sounds, but in my experience, it works. And even when it doesn't, it only serves to greatly enhance your reputation with anyone involved in that matter. It's also consistent with the lawyer's creed from my country, which may also be here in Canada, which I want to share with you today, because if we all follow this aspirational statement, the professional rules of conduct would be easily met. This is really good. To my clients, I offer faithfulness, competence, diligence, and good judgment. I will strive to represent you as I would want to be represented and to be worthy of your trust. To the opposing parties and their counsel, I offer fairness, integrity, and civility. I will seek reconciliation, and if we fail, I will strive to make our dispute a dignified one. To the courts and other tribunals, and to those who assist them, I offer respect, candor, and courtesy. I will strive to do honor to the search for justice. To my colleagues in the practice of law, I offer concern for your welfare. I will strive to make our association a professional friendship. To the profession, I offer assistance. I will strive to keep our business a profession and our profession a calling in the spirit of public service. To the public and our systems of justice, I offer service. I will strive to improve the law in our legal system and to make the law in our legal system available to all, and to seek the common good through the representation of my clients. Now, with that beautiful creed in mind, I want to share a story with you about my early days in practice as a lawyer. I'd been in private practice for about a year when one of our local lawyers was appointed to serve as a judge on the Superior. This is the trial court where I live in Macon, Georgia. He was a sole practitioner, so what typically happened in this situation when the judicial appointee was shutting down his practice, his or her practice, is that the other members of the bar agreed to take over the new judge's client caseload. And as you might expect, the younger lawyers were typically asked to take on the less desirable cases. Well, that's exactly what happened to yours truly. Now, I don't remember all the details of that case, and they don't really matter for purposes of this story. But from what I recall, my client had worked in an insurance agency, had left that agency, and was suing the agency for failing to pay her certain commissions that she believed she was entitled to upon her departure. And so I took up her cause and quickly examined everything in the file because I had to defend her deposition in just a few days after being assigned the case by the law firm I worked for at the time. So I showed up early in the morning of the deposition, which was being held at my opposing counsel's office. I waited in the car until my client arrived, and then we walked into the office together. I immediately approached the receptionist desk, informed her of who we were, then I sat back down with my new client. We quietly chatted about what was going on in her life at the time, and I remember trying to reassure her, because she had never been involved in a lawsuit and was very nervous, that everything was going to be fine. Again, I don't recall all of the details, but I do remember that we sat there for quite some time, long past the time the deposition was scheduled to begin. And finally, after waiting well past the start time of the deposition, I walked back up to the receptionist and politely inquired as to when opposing counsel would be ready to start. She said that he was in the office, but she had no idea when he would be available. Needless to say, I thought this was an odd response, so I kindly asked her to speak with her boss about when the deposition would begin because my client and I had other things to do that day. She looked at me like I was asking her to do the worst thing imaginable, but she walked away from her desk and went to find out when the deposition would begin. And just a few minutes later, opposing counsel stormed into the waiting room of his office, looked at the two of us in utter disgust, and said something sarcastic along the lines of, "Oh, I'm so sorry that I've wasted your precious time this morning. By all means, let's get going." I was, of course, taken aback by my opposing counsel's lack of professionalism, and it understandably only served to make my client even more nervous. But I gave her a reassuring look, and we followed him into the conference room for the deposition. Things went even further downhill from there. Even as a young lawyer, I was stunned by opposing counsel's lack of professionalism and ability to make even the most routine question sound hostile and belittling. Now, I'd been trained to pick my battles in defending a deposition, but I quickly started pushing back on the tone and manner of opposing counsel's questioning of my client. He didn't like that at all. This man had been a lawyer for almost 30 years, and it was clear that he had little regard or respect for a newly minted attorney. Finally, things came to a head. Up to this point, I think I'd done a pretty good job of keeping my cool, but opposing counsel was now literally shouting at my client and calling her a liar. I directed the court reporter to take a break, which infuriated opposing counsel. I then looked at him directly and said something to the effect of, "If you want to continue this deposition, you're going to stop shouting at my client and start treating her with respect. I'm not going to allow you to bully her or me." Well, this sent him into a rage. He told me that I was a snot-nosed lawyer who didn't know anything, that this was his deposition, and that he would conduct it in any way he saw fit. I advised him that if he continued to berate my client, we would be leaving. Again, this only served to enrage him. He then started screaming to me, and at this point, I asked the court reporter and my client to leave the room. They did, and opposing counsel then continued to scream at me for about 5 minutes straight, issuing threats about my legal career and calling me every name in the book. Now, I'm not sure what came over me because I've never been a pushover or someone to avoid confrontation when necessary. But I stayed completely even-keeled the entire time this was happening, and I'd like to think it was because of the exceptional training that I received in law school about professionalism, just like I'm sure you're receiving that here. So I looked at opposing counsel once he paused to breathe in between shouting at me, and I asked him a very simple question. "Hey, are you okay?" At first, he stared at me with incredulity and said, "I'm perfectly fine. Why do you care?" And I said, "Actually, I do care. And I don't think you're doing okay. You're an experienced, well-thought-of attorney in this community, and I was looking forward to learning from you this morning, even though we're on opposite sides of this case. So please tell me what's really going on, because I don't believe someone with your reputation normally acts like this." At this point, he placed his arms and head down on the table and began to sob. When I tell you that this man's life was a personal hell, I mean it. He was going through the worst period of his life. So I just sat there quietly, looked at him, listened intently, and let him vent about everything he was dealing with. And you know what happened next? He sincerely apologized to me for his behavior and asked if I would please keep what happened that morning between us. I told him that I would. I then suggested that we reschedule the deposition. I also agreed to give him as much time as he needed to finish his discovery in the case. Now, I could have handled that situation differently. I could have immediately ended the deposition, called the assigned judge to disclose what had happened, sought sanctions of some sort, reported him to the bar, and let every other lawyer in my community know how he had acted that day. And I would have been perfectly within my rights to do just that. But to what end? Would it make my opposing counsel a better lawyer? Would it enhance my reputation or the reputation of our profession within the local community? I think not. So while others may have chosen a different course than I did that day, I believe my actions amounted to resolute and honorable advocacy and only served to enhance my reputation and the reputation of our profession within the local community, as well as eventually leading to a favorable resolution of my client's claims. In short, my 28 years as a lawyer and judge have convinced me that the most effective form of advocacy is one that treats everyone with respect and dignity. In the end, our cases will be resolved one way or the other, and those resolutions are certainly important to our clients. But what really matters is how we treat each other along the way, as well as the profession we leave to future generations. And while I never had the pleasure of meeting Judge Milvain, I think he would agree with these sentiments. By all accounts, he had a sterling reputation as a fair, hardworking, sensitive, and sympathetic judge. And I'm truly grateful to now be connected to his tremendous legacy. So my challenge to all of you is this: spend a little time each week thinking about what it means or will mean to be a lawyer. Consider what an honor it is or will be to serve your fellow citizens during their most challenging times. And remember that every time you file a pleading or brief, or make an appearance in court, or even when you send an email to opposing counsel, you are either harming or building up your reputation. As I'm fond of telling American lawyers, judges know that lawyers talk about them, but lawyers should remember that judges talk about them too. And even when you lose a case at my court, you can still enhance your reputation by doing excellent legal work in a thoughtful and professional manner. Remember, a legal career is not a sprint, it's a marathon. It's also a high calling. So please, always, always look to the long term. It may sound trite, but the old adage really is true. Your most precious asset as a lawyer is your reputation. Treat it as such. Thank you. Q&A.
That's our job right now. We're here to announce the start of the Q&A. So, hello everyone. My name is Thomas Nguyen. I'm the president of the Society of Law Students.
And my name is Candy Everton. I'm the president of the Black Law Association.
We'll be going around with microphones on both sides of the classroom over here. Flag one of us down, and then we will give you the mic, and then you can have a chance to ask a question to Judge Dillard. So, does anyone have questions to start off?
Can I remove this and walk around too? Is that all right with the cameraman? Okay. All right. I don't like being behind a podium.
Yes. One question over here.
Hi, thank you so much for coming all the way here.
Yes.
And I realize that Georgia does not get a lot of snow, so
No,
you might
don't.
want to visit the mountains before you go. My name's Lindsay. I'm a practicing lawyer in town here. What advice do you have for the students and for us practicing with respect to individuals who don't respond well to your compassion or your respect, and what tools can we use to make sure that we are continuing to maintain that even in the face of incivility?
It's hard. I mean, and you are, make no mistake about it, you're going to run across people in the practice of law that are not going to be compassionate. You know, there's a lot that you can control as a lawyer, you know, giving extensions of time to file, agreeing to certain accommodations to the other side. As I said, the practice of law is really hard. And at some point you're going to need, even if you have a tiny heart that's not full of compassion, it is a bad idea not to establish a reputation as someone that is accommodating to other lawyers. Because, you know, depending on the community, I know this is I think, relatively small community, but I bet the bar is a pretty tight-knit community here in Calgary. People talk, lawyers talk about other lawyers. And so as far as what do you do, I think the main thing you don't do is respond in kind. I think at some point you have to get the judge involved. But I think that should be the last resort. And as a practical matter, giving you advice, document everything. Always as a lawyer. I'm sure your professors teach you that, but like I documented phone calls. I would usually, after a phone call, follow up with an email. and basically memorialize what was said. I would try to do it in a civil way. But I think sometimes even lawyers that are bad actors will eventually give in if they know you are documenting their bad behavior for the court. So I don't know if that answered the question completely, but I hope it came close. Anybody else? Don't be shy. Yeah, here's one right here. Okay, I don't know.
This might not be particularly advocacy related, but like with all of us being in our third year of law school, what is a piece of advice that you would give to all of us as we begin our legal career?
Yeah.
That you wish you knew at the beginning of your legal career?
That's a great question. It's a tough question. So I would say get your first job. I mean, get your first job. After that, if it's anything like the United States, you can go from there. But I think, and understand that your first job may not be the trajectory that you necessarily want to be on. If you are going to go into, since we're talking about advocacy, if you want to be in the courtroom, I would say if you can clerk. That's a great opportunity coming out of law school to see how the system works before you actually have to participate in it. And not just the high clerkships, I guess here I know you've got a Supreme Court, they wear the red robes, kind of the Santa Claus robes. That's really cool. We just have the plain black ones, as you can see. But I would say, look at clerkships. And I think for the one thing I did that I think was a good idea was, and this is just general life advice, and that is to set short-term goals, mid-term goals, and long-term goals. And you want your short-term goals to kind of create opportunities for the mid-range goals and the long-term goals. And so you need to think about, what it is you want to do and how you're going to get there. And sometimes it's not always going to be a straight path. I got out of law school and I was offered a clerkship with the Supreme Court of Mississippi, which is the highest state court in that state, and I really wanted to do the clerkship. My bride is from Georgia. She wanted us to go back to the great state of Georgia. And so we ended up going back to the great state of Georgia. And I joined a firm, and it was a great firm, and I was with them for 5 years. But I always regretted not clerking, and I wanted to do an appellate clerkship. And so I'd been in practice 5 years. I was getting ready to be made partner. With that came a lot of money, and I, through a lot of events I won't go into, had an opportunity to go be a federal appellate clerk for the Seventh Circuit Court in Chicago for Judge Daniel Mannion. And so I gave up a partnership. A lot of people thought I was crazy to do that. I was leaving my hometown where my wife was from. I moved my bride to South Bend, Indiana. We'd never lived outside of the South before. My wife did like the snow while we were there. But I did it because I was thinking long term, and I knew that even though I was going to make a lot of money at the firm that I started with as a partner, that it wasn't really what I wanted to do. And so I was willing to make a financial sacrifice to put me on the trajectory that I'm on. And I'm convinced that I would not be, I certainly would not have been appointed to a state intermediate appellate court at age 40 had I not done that clerkship. And so I guess what I'm saying to you is it's not too early to think about long-term goals, but don't obsess over long-term goals. If you want to be a judge, that's great, but don't talk about it all the time. And do things, the first thing you want to do is be an excellent lawyer. There's an old Southern saying where I'm from, bloom where you're planted. Wherever you are, be the very best at what you're doing at that moment. And if you are the best in the moment, if you are working hard in the moment where you are at that point, people will notice and it will create opportunities for you. The other thing I'll say to you too is say yes a lot. do Bar Association. I'm going to plug the Calgary Bar Association. I know they have a young lawyers division. They're going to have leadership. They probably have a leadership class. They have opportunities. Build up networks. Do favors for, my mom had a saying when I was growing up that doing the right thing is good politics. Right now, you're building relationships with your classmates. And some of these classmates are going to send you business years from now, or they're going to be in a position of power to maybe help you get appointed. So it's never too early to start thinking about where you want to be long term, but you also have to not obsess over the long term. Does that make sense? I'm kind of rambling a little bit, but is that okay? That's how the mind works. All right. Anybody else? Yes.
I also don't need a mic.
Oh, good.
You can come a little bit more. Coming from a jurisdiction that has both appointed and elected judges, I'm curious to know what your opinion on how that sort of reflects the bench.
Yeah.
In the different two circumstances. We don't have the option for an election.
Yeah.
I'm interested in your opinion on that.
I would love to be appointed for life. I would love that. I would love to have life tenure. I was actually appointed first. I was appointed in 2010 by then Governor Sonny Perdue. And so what happens in Georgia is usually there's either a vacancy or an open seat. So sometimes most judges don't finish their term, and they typically will let the governor appoint. So it's kind of a hybrid system in a way, because I would say probably 85% of initial appointments are gubernatorial. And so what happens then is when I ran in 2012, just so y'all, I think I am a good campaigner, but just so you don't think I'm a great campaigner, I ran 2 years after I was appointed by Governor Perdue as an incumbent. So on the ballot, when I was running, it would say Stephen Dillard with a big I. And judges are kind of a low information, race on the ballot. We're down low on the ballot, and not a lot of folks know about us. And thankfully, knock on wood, I've been unopposed in 3 elections. I've never been opposed. I hope I never am. That's stressful. Incumbents usually win. But I think if you're going to have judicial elections, Georgia's system is the best. And I'm not just saying that because it's my home state. We are nonpartisan, so we don't run with affiliated, with a political party. Alabama does that. Texas does that. Mississippi does that. Florida, I think, does that. I think that's outrageous. I say it all the time. I'm friends with a lot of judges in other states, but the idea that a judge is affiliating with a political party that is taking policy positions, to me, is antithetical to the role of being a judge. And so I was telling my driver on the way in, he was asking me about, just like you, asking about elections and all of that. My campaigning style is what I call soft campaigning. It's doing things like this. I view it as a form of civics education. So when I go do campaign events, I usually nerd out about the inner workings and culture of my court, about jurisdictional matters. Not everybody wants to hear about those, but if you invite me to speak, that's what you're getting, or you're getting a professionalism talk. So I don't love judicial elections, but I will say that there is something to public servants being directly accountable to the people. If there is a flaw, I think, in our federal system of life tenure, it is that I have noticed that a lot of my friends who are federal judges are wonderful people, and they very much feel accountable to the people. But I think it can breed, at least in part, a culture where judges are removed, don't feel the need to go out and be with the people they serve. And if there's something I really don't love about the culture of the judicial system, at least historically speaking, is that I think judges often view themselves up here and the people down here. And actually, the people are up here and judges are down here. We are public servants. And I think we ought to act like it. And I don't think the federal system necessarily cultivates a culture of humility in service. And so if there's a benefit to Georgia's system is it forces judges to go out and maybe not campaign in the traditional sense, engaging in kind of political rhetoric, which to me would violate the judicial canons, but it does force you to go out and hear from people and meet people and hear their concerns, because there are some things we can talk about, like access to justice, right, issues. We can't talk about cases, we can't talk about policy issues, but we can talk about the administration of justice and how to make it better. So I hope that answers your question.
Thank you. For the next few questions, we do insist you use the microphone so audience members can hear you.
I guess they're taping, so that's why they...
Hi, Judge Dillard. I think this might be a long-winded question. I'm just wondering what your thoughts are on how the judiciary in the U.S. can uphold the rule of law in terms of what we're seeing right now. It feels like the ends kind of justify the means, even for us as lawyers. When we see certain things, from my perspective anyway, as the ends justifying the means, like how do you resist that temptation to do whatever it takes to succeed type of, as you were speaking to earlier, but from a judicial perspective, how will you kind of help maintain the rule of law in that way?
I think it's a great question, and I can read a lot of layers into that question. Here's what I think I would say about that. I think one of the things we have to do as not only as a judiciary or a judicial system, but as a people, is we have to do a better job with civics education. There are too many people in the United States that when a decision comes down from the Supreme Court of the United States, they don't read the opinion. It is, and most lawyers are this way too. I mean, the lawyers are not exempt from this criticism I'm about to levy. Whether or not I agree with a decision from the Supreme Court of the United States depends on the outcome. And the reasoning matters. Now, if somebody has read one of my decisions and they are critiquing the reasoning, I don't have a problem with that. But we have gotten to a point, at least in the United States, where everything is politicized. We've politicized the federal judicial nomination. I mean, that's one of the things when people ask me about judicial elections. I'm like, state judicial elections in many cases are far less political than the federal judicial nomination process. The idea that an appointment process is devoid of politics is a fallacy. So I think what I would say, if you disagree with the policies that the way the executive branch or the legislature is acting, and you don't feel that the judiciary is serving as an appropriate check on that, then you've got a couple of choices. You're getting great training as a lawyer. Run for office, eventually. Stay engaged, be involved in policy. There's think tanks you can join. There's things that you can do as a lawyer, as part of the bar. I think the thing that I'm having to, and this is a little personal for me because I've got a senior in college right now who wants to go to law school, and she's echoing a lot of the same sentiments that you are. And what I tell her is the answer is not to give up. If you don't like the system, be part of it and make it better. This is, there may be a time period where you don't agree with either the current composition of the Supreme Court of the United States, or you don't like the person who's leading your country. But the answer is to stay engaged and to believe that the legal profession can and has been a powerful way of correcting injustices in society. And so I don't mean to be overly optimistic or overly hopeful, but I hope that you're going to law school in part because you want to be a difference maker, that you see this as an opportunity to serve others. And you don't have to always practice law. There's a lot of people that have law degrees that go into government. Lord, do we need lawyers in government? In our Georgia legislature, our state legislature, we are down to, it used to be dominated by lawyers. And as someone that has to interpret the laws that are passed, not having lawyers in the legislature is bad. It is really a battle for someone that has to deal with statutory construction issues all the time. But, I would say, be not afraid. I don't want to be cliche or cheesy, but, hang in there. I mean, fight the good fight. If you believe in a certain vision for the judiciary, as long as it's based on the rule of law, as long as it's not simply a means. My issue with both sides is that I think people you view the courts as a means of achieving policies that they can't otherwise get passed in the legislative arena. And they're really, the separation of powers really does matter. I assume that y'all have the separation of powers here, right? That's not just nerdy stuff we talk about for 15 minutes in con law. It's important. And the judiciary needs to stay in its lane. I mean, the reason, and if that doesn't happen, you're really going against your own interest as lawyers, right? Because ostensibly, the reason why lawyers become judges is because we're actually doing law. We're actually interpreting law. We're actually looking at precedent. We're reconciling precedent. And so if that's not what we're doing, if we're just doing what we think is right, if I'm just doing whatever Judge Dillard's personal philosophy is, that to me is undermining the rule of law, and it's a disservice to the people of Georgia, and it to me is ultimately destructive of our judicial systems. We have to, as much as possible, and I know people are going to roll their eyes, we need as much as possible to keep politics out of the legal system. I know it's impossible. I don't want to be Pollyannish about it, but we need to try to do that, and we need to let those fights happen in the legislative arena and then do law as lawyers and judges. Anybody else? You just got a little preaching going on. Yeah.
I have a question about TikTok.
Okay. I don't know how specific I can be. I do not have an account. If that's your question. I don't do any dancing or.
So
you
the
wouldn't want to see
Supreme
that.
Court upheld a decision that that banning TikTok did not violate Americans' First Amendment rights to the
Right.
freedom of speech because they believed that it was more of a national security risk.
Yeah.
What's your take on that?
I can't comment on the decisions of courts that review my homework. And it wouldn't, even if I could, it wouldn't be wise for me to do so. I do think, and I'm not accusing you of doing this, but I do think that particular issue and the legislation at issue and the fact that you're kind of talking about like not so much content, but like who can own, and where that information is going. I think there's some really interesting issues on both sides, and so I'll leave it at that. But I do think that case is a really complex area of the law, and you see this a lot in American jurisprudence, especially the Supreme Court's jurisprudence, where you have kind of what the general law is, and then like when you have national security issues involved, like how does that interplay? How does that work? And so this First Amendment is not the only area where we see like national security having implications on a particular line of jurisprudence. But, it's complicated, and that's why they don't pay me the big bucks to be on the Supreme Court of the United States. So I'm glad I'm not on this. I tell people all the time, I think I have one of the best appellate jobs in the country. When I was younger, I would have been like, of course I want to be on the Supreme Court of the United States. Now, no thank you. No thank you. Don't want to be in D.C. I like what I do. So, not that it would ever happen. Anybody else?
And this will be our last question.
Okay.
First of all, thank you for being here. You briefly touched upon the separation of power, but I believe it was in one of my classes that I learned in Canada. Specifically, we don't have that interplay between the judiciary and the legislation. There are gaps between the laws that cannot be filled by judicial. I'm interested to know how that system works in the U.S.
Yeah.
In Canada, specifically right now, as far as I know, the system is to write about it. That is the advocacy that they're doing, to write about the problems of the law that cannot be fixed or cannot be interpreted anymore, and they're referring or calling upon legislation to change the law.
In the judicial opinions.
In the judicial opinions. How is that in the U.S., how that system works?
We do some of that too. I mean, maybe it is that we have a harder line of separation of powers in the United States, but I like the separation of powers because I wanted to be a judge to interpret the law, and if a law is unclear, I don't feel comfortable being the gap filling, because if my values and your values align, then you might like the gap filling that I do. If he has different values than us, he might not like the gap filling that I'm doing. And by doing that, now obviously the legislature, I suppose, could come back and fix it if they don't agree with the way I interpret the gaps or the ambiguities in the law. But I just think that is antithetical to being a judge. And so I've written opinions where I say, this outcome seems really harsh, but this is using my interpretive, interpreting the law, reading. We have what we call canons. I assume y'all have the statutory canons of construction as well. Using the canons, I've exhausted everything, and this is the most natural reading of the statute. And sometimes I'll invite the legislature and say, y'all might want to take a look at this. And sometimes maybe that opinion gets faxed over to legislative council by somebody, not me, but by somebody else. And so the legislature sometimes will step in and fix it. We had a case that I was on a few years ago, and it was, have y'all ever heard of upskirting? It's when someone can take kind of tries to take photos of somebody. It's really offensive under their, like at a grocery store or something, or, and we had a case where a guy had been charged with a crime. And the problem is that the Georgia laws had not gotten to the point where they could account for the advancements in technology. And so this guy was charged under a statute that didn't really fit the crime. And as awful as what this guy did was, it's also awful to put people in jail and convict them of a crime when they're not given notice. And we also have this concept in the law of the rule of lenity, that we interpret statutes. If we're unsure, we do it in favor of the criminal defendant whose liberty is being taken away. So we ended up, I was in a majority, there was a dissent. I was in the majority that said, you can't convict this guy, they need to pass a law. And there was uproar. I mean, it was not just national uproar, it was in on the BBC website, and, Georgia court thinks it's fine for people to, which is a whole nother problem, which is not, they clearly didn't read the opinion, because in the majority opinion we said, I didn't write it, but I joined it, and we said this is morally offensive and should be legally prohibited. But you have to be able to make those decisions as a judge for the sake of the rule of law. You have to. There was a Supreme Court justice many years ago said that if you're a good and faithful judge, you're not going to like all of your decisions, and if you do, you're not a good and faithful judge. And so, if you put on the black robe, or in Canada's case, the red, with the white fuzz. If you put that on, you have to be willing to kind of set aside your personal policy preferences. So it's hard. And I have lawyers all the time that tell me I couldn't be a judge. I couldn't make those because I would want to do what I think is right. And that seems instinctive to us, like just do what's right. But when you've got a society where not everybody agrees what right is, then we have to hash those things out in the legislature. And judges need to leave those things to the legislature, in my view. All right. Is that it?
Yes, that's it. That's the end of the question period.
Thank you all very much.
Okay, thank you, Judge Dillard, for your lecture, along with everyone else's questions and answers. On behalf of the Calgary Bar Association, the Faculty of Law, staff, and students, we would like to present you this plaque for your lecture today.
Oh, thank you so much. I don't want to drop it.
Oh, yes. Stand over here for a quick picture.
There, perfect. Thanks so much. Perfect. 1, 2, 3. Thanks so much.
Thank you so much.
Okay. Next, we'd like to move on to our next section of today's event. We would like to welcome Zaylene Laku. Zaylene Laku is the Vice President of the Calgary Bar Association. She was called to the bar in 2009. Called to the bar in 2009 after obtaining her law degree at the University of Ottawa. She's a Crown prosecutor and has been a Crown prosecutor in Calgary for 10 years, prosecuting a variety of sexual offenses against children and murders. Zaylene is also the Vice President of Franny's Fund, a charitable organization dedicated to raising money for children victims and raising money for those who are participating in criminal justice system. Please welcome Zaylene Laku.
Thank you, Thomas and Tammy. Good afternoon, everyone. I'm Zaylene Laku. I am a Crown prosecutor at the Calgary General Prosecution Office. And I'm here on behalf of the president, who couldn't be here today, Adriano Ivanelli, who many of you know. First and foremost, I would like to thank the Honourable Judge Dillard for his most excellent lecture today. Judge Dillard, we're very fortunate to have had this opportunity to hear you share your knowledge and wisdom, experience, and insight with us, and I can say that it was very relevant, it was very helpful, and I think that the wisdom that you imparted on the students today rings true for lawyers in Canada as well. You are the first ever Milvain recipient from outside of Canada, and certainly you've set a very high bar for your American colleagues, so thank you. I would like to also extend a very special thank you to Dean Oshinebo, Peter Desmond, Gideon Christian, and Wilma Shim, and everyone else at the Faculty of Law here at U of C for their hard work and commitment in putting this lecture together. The Calgary Bar Association and the U of C Faculty of Law began its partnership for this lecture in 1979, so that makes this our 26th year. We're very proud of our strong relationship with the Faculty of Law on this important program, and we look forward to continuing over the next 25 years. It is our hope that many of you seated in this auditorium today will be the recipients of this honor in the years to come. We also look forward to welcoming all of the students in attendance today to our membership. If you're not already part of it, for those who don't know, the CBA has been in existence since 1890. So we're old, but we're very fun. One of our objectives is to promote civility and collegiality and professionalism, which Judge Dillard really spoke about today. So amongst our members, there is a sense of collegiality and professionalism as we gather together outside of the courtroom. This really means we throw amazingly fun events for lawyers and judges to gather and let loose and to celebrate each other and our accomplishments. In Calgary, the CBA is responsible for throwing a number of events yearly. You may have heard of some of them. So when lawyers are designated with their King's Counsel, there's an event to celebrate that. When judges are appointed to the Alberta Court of Justice or the Court of King's Bench, we throw events to celebrate their successes in that regard too. We also have stampede celebrations. You can imagine what those look like, and golf tournaments. So when we bring our members together of the Calgary Bar Association at our annual events, we also get an opportunity to fundraise. And so we're able to give back to many charities and societies in the legal community, including Student Legal Guidance, Calgary Legal Guidance, Student Legal Assistance, Drug Treatment Court, and Pro Bono Law. If you think you want to be a part of the CBA, know that all students, law students, are very welcome. You can visit our website at calgarybarassociation.com. And also, please give us a follow on Instagram at Calgary Bar Association. Our goal today is to get more followers than Judge Dillard on Instagram. So, thank you. Finally, I want to conclude by presenting Judge Dillard with a small gift from the CBA, reflecting our appreciation for his attendance and involvement here today. So, Judge Dillard, this gift is a highly coveted, limited edition Calgary Association belt buckle. We hope that you'll return for a second visit to Canada. During the Stampede, it's really the only place you could wear it and not be made fun of. Thank you. Thank you, everyone, for attending, and I'll just invite Professor Christian to conclude the program. Thanks, everyone.
Thank you, Zaylin, and also thank you so much, Judge Dillard, for accepting to be the 2025 Milvain Chair and also traveling to Canada to deliver the Milvain Lecture. We do appreciate the important issues you raised in the course of your presentation. As a professor who teaches ethical lawyering, I think I could reasonably resonate with what you said. It's a very important and topical issue for our students. So thank you very much. And for our students, we are privileged to have Judge Dillard for yet one more day. So tomorrow, he's going to be here in person, and you're going to be hosting him in your small group as he reviews your preparation for your final trial on Saturday and provide feedbacks to you. So please use the opportunity to ask him questions about advocacy. On a light note, may I kindly request that you please don't ask him questions about tariff and annexation, please. So, having said that, I want to use this opportunity to invite you all, especially our guests joining us in person and virtually. Thank you so much for taking time to attend the Milvain Lecture this year. I want to use this opportunity to invite you in advance for the 2026 Milvain Lecture, which is also going to be delivered by another Milvain Chair we don't know yet. It might be from the US, it might be from some other place, but we'll keep you informed. So thank you all so much for taking time off your busy schedule to be here today, and also thank you, Judge Dillard.